I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your boy TP. Today we are at number 212, and on 212 we're going to be featuring 4 judges. And before I give you their names, don't forget to like, comment, share, and subscribe. It has been a pleasure reading some of you guys' comments. I'm not always able to get to all of them, but I try my best. But thank you for everything that you guys are doing with the sharing, the liking, the commenting. It all helps the channel. Also, there will be commentary left in. If there was any commentary in these proceedings, there will be chapters added for your convenience. And now let me give you the rundown of the 4 judges' courtrooms we will be in on today. First, for the first time, we will be in the courtroom of Judge Melissia Mogen out of the state of Wisconsin. Shout out to Sovereign Citizen Chronicles for sharing this proceeding with me. Second, we will be in the courtroom of Judge Tammi Hayward out of the state of Georgia. Third, we will be in the courtroom of Judge Guerrant, also out of the state of Georgia. And last but not least, we will be in the courtroom of Judge Sean Perkins out of the state of Michigan. Now it is time for us to jump into 212.
Muted, and I hit a button to ask you to unmute, and I'm now hit something to ask you to start your video. There you are. How are you doing today? Are you Mr. Locke? I don't know what's going on. I should be in there. I will hit a button again to ask you to unmute. There.
There we go. All right.
Are you Mr. Locke? Ryan? Are you Ryan? Because I'm going to tell you, I need to understand who you are, because when I saw you at the last hearing, you were in custody and you were really, really tiny. So I need to be able to know, so I can put your picture of your face in my head to associate things. So I am speaking with Ryan Locke.
Object.
Sir, well, if this is the route it's going to go, and I think I've been very super fair to you, and with your bail and with all of those other things, if this is how it's going to go, then I will never allow you to be by Zoom again, and we can get a warrant and we can go that route. So if you want to cooperate and you want to participate and be nice to me as I am nice and respectful to you, how would you like to go about it?
I am trying to speak, and you are.
All right. So here's all about your contract and how you're going to hold me responsible.
I'm not contracting anybody. I'm not saying any of that.
Well,
I'm just trying to speak my
so then
constitutional rights. That's it.
On your birth certificate, did your parents name you Ryan Locke? Yes or no? And I did grant you leniency, Mr. Locke, to appear by video. I have every right to never allow that to happen, ever. You understand that? Yes or no?
I'm asking you. Can I ask you a question?
Nope,
yes
not
no?
Unless you answer my question. Do you understand what I said? Yes or no?
I object, and it sounds like the court is trying to get me into their jurisdiction.
All right, we will go on the record in the matter. 26 CF 46, 26 TR 306, State of Wisconsin versus Ryan Locke. The state appears through District Attorney Kevin Schmidt in person. We have Emma Hanu appearing in person. Ryan Locke appears by video conferencing. He did call and ask permission of the court. He was being a cooperating individual and a human being. However, he is failing to cooperate here today. Therefore, the court is stating on the record, at no time in the future, at any time whatsoever, Mr. Locke, may you appear by video conferencing or telephone. Your hearings will always be in person hearings. With regards to today, the court will quash the warrant. I don't have to do that, but I'll be nice and I'll quash the warrant. I'm resetting it to another date and time. Ms. Hanu has asked to withdraw. I usually ask for information and go into it. I'm not going to today, Ms. Hanu. You may be withdrawn. You were legally served. I have all of that information. So I do know that because you were in my custody and the court did give you leniency, did modify your bond, was trying to work with you, Mr. Locke. However, you refused to work with the court, and the court finds that to be completely disrespectful. Therefore, I am setting this for another date and time. Mr. Schmidt, is this a your case or a Fillet case?
It is Assistant District Attorney Villard, Your Honor.
That's correct.
All right, so what I'm going to do here today is I am resetting it for May 27th in person at 2:45. May 27th, 2:45. We shall see you then. I strongly recommend that you call the public defender's office and you get another attorney appointed to you. I'm resetting it. Thank you very much. Please? We are adjourned. Bye.
Guys, really quickly before we go on with the rest of this compilation, being that it was my first time being in Judge Mogen's courtroom, listen, we only got a little snippet of how she gets down, but this lady, don't let her face fool you. Her calmness, she went from 0 to 100 real quick. She was not playing with Mr. Ryan. I hope to see more of this judge. I'm sure you guys are going to have a lot to say about her in the comments because, man, when I say she went from 0 to 100 real fast, man, did she. But let's go ahead and jump into the rest of this compilation.
Mr. Resto. So Mr. Resto, you have two cases. You have case number. You hear me?
Yes, okay. I hear you.
So you're before the court on 2019 CR 04954 for driving on a suspended or revoked license, no license, failure to display license, or failure to have license on person. I'm not sure, it cuts off, and no tag or expired or invalid tag. So that's on the first case. On the case from 2020 03114, you have a suspended or revoked license. You're represented by Lister and Holt on one of the cases, but not on the other. Did you want Lister and Holt to represent you, or did you want to represent yourself?
I'll represent myself.
On both cases?
Yes, ma'am. I have a quick question as far as lock return when it comes to driver's license.
Okay.
Okay, you're only allowed to have one driver's license, and I have an Alabama driver's license. So when I get pulled over, I actually show them my Alabama driver's license, and it's current. It's the most current, and so they make a determination if they should go off the Georgia driver's license or the Alabama driver's license. And when I present the Alabama driver's license, they let me go because my Alabama license is valid, and you're only allowed to have one. And I had Alabama license first. So I
believe
Georgia
this sounds like a not guilty.
Okay, so Mr. Resto, what Mr. Taylor is saying is this is something that you could prove at trial. If you present that information at trial, then that means you want to go to trial instead of taking a plea. I don't know what the recommendation is, and I don't know.
Well, the recommendation was, I think I've been dealing with this case for an awful long time now, so I don't really want to go to trial. I just want to get it behind me. But I think that the recommendation, I remember the recommendation quite clear. They offered me 40 hours of community service. Is that still on the table?
Okay, no, Mr. Resto, it's more than that. So let me explain why I know it's more than that. So the basic fines and fees for driving on a suspended license is the first time in 5 years. If you get one, then you can enter a NOLO plea if you have a NOLO plea eligible to you. And then the fine is $500. But if you get a second one, the fine goes to $1,000. A third one, the fine goes to $1,500 and 10 days mandatory jail time. You have a second one, which means that you might be able to enter a NOLO to the first one, but then the second one is outstanding. So when you took a plea to the second one, that would definitely suspend your license. So that's what's on the table.
Okay.
And the fines are hefty. So you would get a plea on the first one, and that's a $500 fine, which is $737.50. But the next one is going to be $1,000 in addition to that, and that's $1,420. So we're looking at almost $2,200.
Your Honor, is Mr. Resto represented on the particular case that we're referring to?
Well,
I
I
want to
don't
address
know.
him directly if he's
So-
represented, because this is a serious matter.
I get you. So that's why I'm saying, Mr. Resto, you have representation. I can allow you to be represented on both cases, and they can help you work this out. But understand
Well,
that
I was already represented by Lister and Holt, and we kind of been going back and forth with the district attorney's office for a while, and they've been giving me recommendations, and I still didn't take it, but they've been giving me recommendations. I don't know what's changed, but it definitely wasn't $2,000.
talk to your attorney and let them tell you what the recommendation they have on the table, okay? Because the recommendation, if you're represented, even if you're only represented on one case, the rec is probably going to come to your attorney.
Okay, now if I enter like an oral motion of dismissal based on constitutional grounds, are you standing on your constitutional oath?
Okay, I'm not sure what that is. So I have taken an oath to uphold the Constitution and to make sure that I treat people as the law would direct me to do so. So,
okay. Well, I asked this question previously when I was in your courtroom one day in regards to the right to travel under the 14th Amendment, stating that citizens do not need a permit to travel with a horse-drawn carriage, wagon, or automobile without interference by police. And I was on a public highway actually when I got pulled over.
Okay, so that's not actually in the Constitution.
And so I don't believe automobiles were around when the 14th Amendment was ratified.
I'm sorry, go ahead, Mr. Taylor.
I just wanted to point out to the court that automobiles hadn't been invented when the 14th Amendment was ratified.
It says automobile, horse-drawn wagon, or carriage.
Okay,
so an automobile is not necessarily a car if it's a household good. It's just a form of transportation. It doesn't matter if it's an automobile, horse-drawn wagon, or carriage, because it's still a form of transportation, and citizens have the right to travel without interference by police. So I don't even know how the police are even allowed to interfere with travel when I'm not using my vehicle for commerce.
Your Honor,
it's a totally private household good.
Okay, so Mr. Resto, if somebody drove 100 miles an hour into the back of your vehicle and killed a family member, would you want the police to interfere?
That's a murder. I mean, that's if someone got killed.
But they're traveling. You can't interfere with somebody traveling.
No, I mean you can't. It's stating that a police just can't interfere with your traveling, like pulling you over for a traffic violation or a tag.
But you want them to interfere if somebody.
Now, if you murder somebody because
say you don't murder them. Say you just hurt them. Say you just damaged the vehicle. You don't want the police to interfere.
No, that's when it almost becomes like an accident or a crime or whatnot. So the police that's not really an interference. An interference with your traveling, not an interference when two citizens engage in an accident. It's interfering with you just traveling. Now, police officers, as far as public servants, they have a duty to serve to the people. So if a car accident occurs, then of course, public servants, as far as ambulance, as far as firemen, they will come to the scene just as a service. But for you to just interfere in my traveling is actually a violation of the Constitution.
Well, sir, the Constitution and the cases that have come out of the constitutional jurisprudence allow cities and states and municipal organizations to regulate travel for the benefit of the citizens. So they can put reasonable regulations on travel, meaning you can have a license They can grant you the privilege of having a license to drive. They can regulate how your license is seen. If you don't have a license, or if your license is suspended, they can intervene to take your license away or your privilege to drive away. It is a crime. You can be convicted of not driving under a proper license. So the government is allowed to intervene in a lot of ways with people traveling. So I'm not sure where this information comes from, but there's a lot of stuff on the internet about traveling and the 14th Amendment and horse and buggies and even maritime law. But
I mean, an automobile was actually created before a driver's license was ever created. So people was actually their case pamphlets where people was actually operating vehicles before a driver's license ever became. That's actually, you guys are actually a conflict of interest, actually, as far as you being in cahoots with the DMV. That's a totally separate entity.
Okay,
and for
so
some reason,
Mr. Resto, do you want to resolve the case? Because it's not
I want to resolve the
40
case.
hours.
I disagree with the fine amount because it changed. I would I would make an offer like I can do $1,000, maybe 12-month probation.
Mr.
But $2,000, that's excessive.
Mr. Resto, we're not negotiating. Those are statutory fines, meaning they're written into the law. I can't even change them.
Can I make a counter offer to the state and say it's $1,000? Can I be?
No,
because I did do time in jail. If the state would see that and count.
That's why I'm saying that you may want to speak with an attorney, because certain things that they can negotiate, I can't change the statute. I can't change what's written in it, but they can negotiate. And if the solicitor wants to give you credit for time in jail in lieu of the fine, those are things that they can do that I can't do.
Yeah. So I would ask to the district attorney, knowing that I did serve some days in jail, can you guys lower the fine and I just go ahead and end this case right now? I can do $1,000. I got $1,000 right now.
Mr. Resto, so that's a conversation that you need to have with them directly without me being present, number one. Number two, the reason I keep saying you might want to go through your attorney is because they can explain to you what is already on the table and how that may or may not change, okay?
What's on the table now?
I don't know. That's what I'm saying. I would rather you have that conversation in a breakout room with the attorney who's assigned to your case and with the state, as opposed to here in the main room. One, because I have other cases that need to be addressed, and two, because that's not information I need to hear.
Okay, is it anything I can do to get this case resolved now? Because it's been lingering on.
I'm telling you what to do, but you're not listening, Mr. Resto. I
mean, today, I want to resolve this today.
I get that you want to resolve it today, and I'm telling you what to do, but you're not listening to me. I said you can go into a breakout room with your attorney, and the attorney and you can discuss what's already on the table. And then if your attorney wishes to speak with the state to clarify anything, they can do that too. But you're not going to get it resolved by going back and forth with me, because there's stuff I cannot do.
Okay. Just tell the state that I'll take their recommendation. I'll just pay the $2,000 if they can give me 12 months to pay it off. And if I pay it off early, if my probation would be terminated, that would be great.
Sorry, I was discussing with Mr. Resto, and I understand something changed about his bond.
Okay. He has bonds with two bondsmen. I don't know of anything. Does he have, did somebody come off a bond?
Your Honor, maybe I can address that question.
Okay.
Mr. Resto, our office filed a motion to revoke bond, and that motion was granted a rule nisi, and it was calendared. That motion didn't happen because of the pandemic. It was, I believe, scheduled to happen in 2021, maybe February, but somewhere about that time. I informed Mr. Kamani to inform his client that depending on the outcome of today's arraignment, the state intends to move forward on that bond revocation. Your Honor, may I make a request on that matter?
Sure, Mr. Taylor.
I'd request that the defendant does show in person for him. Zoom court is or remote appearance is not sufficient.
So it's my understanding that you and Mr. Castaneda have parted ways with respect to your case.
Yeah. Did he file a motion to withdraw?
Yeah. Did you want to go forward without an attorney representing yourself?
Yeah, it seems like the attorneys that the state appoints me, they have a very hard time of like listening to their clients, like what they have to say. Like I had a conversation with him for like maybe 5 minutes, and he was very like wanted to do what he wanted to do. He didn't want to hear what I had, or he was just telling me like I was raising concerns about the state came off of my bond, and I was trying to figure out why they came off my bond when I show up for court. I gave him no reason to come off my bond. And he said,
so when you say come off your bond, the bonding company has to do that, not the state. So I'm not sure. Like,
well, they filed a motion to come off my bond. That's what he stated.
Okay, is that Free at Last or Atlanta Clayton bonding?
No, not Free at Last.
I have that you.
He stated that the state filed a motion with your court stating that they wanted to come off my bond to where basically I would have warrant on me.
Okay. Miss John VA, do you have any outstanding bench warrants for Mr. Resto? I don't recall signing any, but I may have.
Did the state file any motions in regards to
that? No.
Okay, I did. So just Your Honor, I didn't know that he was back. I'd already given the file to my assistant. She said she had just sent off the bench warrant to you as well, I think. So
I didn't think.
Okay.
All right. So yeah, Mr. Resto, you're here. So I haven't signed anything yet.
Okay. Does the state have any intentions on trying to come off my bond?
No. So, sir, they don't come off your bond unless you fail to appear. My understanding is you had a medical excuse for being late today. So you contacted
I'm actually still at the hospital. I just had a minor surgery.
Okay. So Ms. Val has allowed you to come on to the call today because she knew that you had a medical issue. So we can deal with your case today, or we can give you a continuance until December 6th, but nobody's coming off the bond and the bench warrant will not be signed.
Okay. I want to handle this today. It's kind of been lingering over my head for some years now. I'm really tired of it. And but I hear that the state is trying to like give me like 10 days in jail, and that would like absolutely ruin my business, my life. So I have a 2-year-old son. I'm a single father. Yeah, but see, Judge, in my situation is I got the documentation from the Alabama motor vehicle department. See, I'm actually an Alabama citizen.
Hold on, Mr. Resto. Hold on. Let me put you in a breakout room with me and the state so we can hear what you're saying, but we're not putting it all out there in case you want to make a different decision, okay?
Okay. Well, I have no absolute reason to lie, and I really believe
it's not that, sir. This is what I would do if you had an attorney who was representing you, okay? So this is called a pre.
Yeah, but I just honestly believe that when you're just being truthful, there's really no need for attorneys when you're just being honest about your situation.
Next is Mr. Resto. Mr. Castaneda was fired by Mr. Resto, so he's no longer counsel of record. Mr. Resto is wanted, and there is no surety on that. Does the state have it? There's no surety order on that. Does the state have a request in the Resto case?
Mr. Resto, yes, state would definitely request a rule absolute on that matter.
Okay, on both cases, a rule absolute will be granted.
Thank you, Your Honor.
That's 16 with Ms. L, Mr. Saunders. All right, so Ms. Germany, Ms. Saunders, and Ms. L, Mr. Saunders, I'm sorry. If you could all please unmute and raise your right hands. I'm just going to swear everybody in. Ms. Germany, if you could unmute for me. You're muted.
Sabrina, okay.
There we go. All right, thank you. Miss Germany, if you could please raise your right hand. All right, do you all swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth under penalty of perjury?
Affirm.
Okay, thank you. All right, thank you all. You can all put your hands down. Okay, so I did previously review the case. Mr. Saunders or Ms. L have filed several documents. I'll let you make your presentation, but I don't see that they're actually responsive to the petition. I'm going to let Mr. Duda put on his case, and then we'll go from there.
Okay. Yes, Your Honor. We would initially file for a motion for judgment on the pleadings, but I'll, Sabrina, if you can unmute, please. Sabrina, there you go. Sabrina Germany, can you please state your name for the court, please?
Sabrina Germany.
And with whom are you employed?
Invitation Homes.
Okay. And is Invitation Homes currently the management company for SFR XII ATL owner 2LP, the plaintiff in this case?
Yes.
And when did Invitation Homes is to the best of your knowledge, is SFR, is the plaintiff the owner of the property located at 4348 Carrollwood Drive, Stone Mountain, Georgia 30083?
Yes.
Okay. And when did Invitation Homes begin managing that property for the plaintiff?
December of 2023.
Okay. And to the best of your knowledge, do the defendants, Tankia Hodges and Jared Saunders, are they the named tenants on the lease for that property?
Yes.
Okay. And what is the current monthly rent for that property?
$2,195.
Okay.
Base rent.
And pursuant to the lease, are late fees allowed to be charged after what's the late date stated in the lease?
Yes.
And what's the amount of the late fee?
10%.
Okay.
$219.50.
Okay. And since December 1st of 2023, have the tenants made any payment towards the rent in this property?
No.
Okay. And what is as of today, including May's rent, what is the current amount due?
$15,384.98.
Okay. And
what would it be through?
I would need to prorate that real quick, Your Honor. I should have been doing that when I was waiting, but I didn't.
That's all right. That would be the 22nd.
And see. Okay, so the prorated amount through the 22nd is $1,557.74. So subtracting, let's see.
What was that number again? The prorated amount?
Yeah. Let's see. It's $1,557.74. So the current balance prorated through the 22nd is $14,747.72. That does include a late fee for May. I'm not sure if the court allows late fees after the filing of the case, though.
Since it's a prorated, why don't we just take that off? That's $219.
Okay. Yeah, so that would subtract an additional $219.50.
219.50. So that's 14,528.
That sounds right, yes.
Okay. All right. And that represents rent from January through 22 days in May, minus the
It would be from December of 2023 through May 22nd, right?
Oh, so the last payment was actually in November?
My client, Invitation Homes, took over management of the property on December 1st, and at that point in time, they just treated it as a zero balance and went forward from there. No payments have been made since my Invitation Homes has taken over management of the company or the property.
So no payments were received in December?
Correct.
All right. And the monthly rent is $2,195?
Correct.
Okay. All right. Anything else?
No, I believe that's it, Your Honor.
Okay. All right. So Ms. L and Ms. Saunders, I can't have you go at once, but Ms. L, if you have some questions for Ms. Germany, you can ask her some questions now. You don't have to ask her questions, but if you wanted to ask her a pertinent question about her testimony, you can do that.
I mean, Judge, I stand affirmed that documentation I did not submit, but that did retrieve later, does not affirm the information that she stated true, correct, and complete. That's why I recorded an affidavit of truth, correct and complete to the court.
Would you want to ask her any questions, though?
I have no questions for her.
Saunders, do you have any questions for Ms. Germany?
No, ma'am.
Okay. All right. So Ms. L, and Mr. read through all the documents that you presented. I'll let you make a very brief statement about it if you want, but as long story short, they do not present a legal defense to having signed the contract and being obligated to pay rent in this case. So none of the stuff that you put in there is going to be a defense to that. Like I said, if you want to make a brief statement, you can do that. But outside of that, that is, after having read through all of the paperwork you submitted, that is my position based on what I've read that you put in. But if you want to make a brief statement, Mr. Saunders, if you'd like to make a brief statement after that, you can do that. Ms. L, if you'd like to go first.
As I said, Judge, I sent the affidavit. I take full liability under oath. With the demands listed for the plaintiff to rebut point for point as a counter affidavit. The plaintiff didn't rebut the point for point under oath, under penalty of perjury, which means the affidavit stands as truth. Also, Judge, this affidavit stands as judgment in commerce in a tribunal or court. The plaintiff also was using my information, my personal property that I have a claim to. If you see page 2 of Exhibit C and Exhibit B, pages 1 and 2, it states that information.
All right. Mr. Saunders, do you have any statement you'd like to make?
Yes, I affirm that I'm a witness to everything she has stated in the documents and the affidavit and putting her lawful identification on the record. Everything is notarized, true, correct, and complete, and she does take full liability for everything stated and the validity and veracity of everything stated in the documents.
Okay. All right. I think that Mr. Duda, do you have anything else?
No, Your Honor. Just if the court is going to issue an order in our favor, there is a mention of in their response to some $500,000. I'm not sure if that's considered a counterclaim or not, but we would ask that the court basically deny any asserted counterclaim.
I did not interpret it as a counterclaim, but if it is a counterclaim, I will deny it. So I will issue an order today. I do find that there is a valid lease between the parties and that the amount owed, that there has been no rental payments made since December of 2023. I am not allowing a late fee for May, but rent, including late fees, 80%, will total $14,528.22. I will go ahead and issue that order. And unless anybody has any questions, you are all free to go. Go ahead, Ms. L.
Thank you, Your Honor.
Judge, I am asking the Honorable Judge of the finalized contract between me and the plaintiff for the amount stated in the first part of the Exhibit A.
Okay. As I mentioned before, I did review all of your documents. They have no legal validity, and that is my finding. So I'm going to go ahead and issue order in this case. You are all free to go. You will get a copy very soon of the order. Okay? All right. So Mr. Duda, Ms. Germany, Mr. Saunders, and Ms. L., you are all free to go.
Thank you, Your Honor. Have a good day.
You
Thank you. Have a good day.
This is the City of Detroit, Mr. Berry versus Destiny Graves, case number SB 1069059, counts 1 and counts 2, SB 172478881, SB 1724805, counts 1, 2, and 3, and SB 1724836. Appearance for the city.
Elwood S. Berry Jr. on behalf of the defendant. State your full name, Ms. Graves.
Good morning, Your Honor. I am Destiny Raven Graves. That's capital D, lowercase ESTINEY, hyphen, capital R, lowercase AIVYN, colon, capital G, lowercase RAVES. I am appearing specially and not generally. I am here in good faith and under the protest solely to address the matters raised in my plea abatement. I am not here to delay the process, but to ensure proper identification and lawful jurisdiction are established on the record before any further proceedings.
All right, good morning to you, ma'am. Today is the date and time set for arraignment on the bench warrant. Would you like counsel to represent you or no?
I'm sorry, can you repeat that?
I said today is the date and time set for arraignment on the bench warrant. Would you like counsel to represent you or not?
I actually am not open to proceeding until we establish jurisdiction over the living woman. That's me, lowercase ESTINEY, hyphen, capital R, lowercase AIVYN, colon, capital G, lowercase RAVES.
Okay. Jurisdiction has been established if you are Destiny Graves. If you're Destiny Graves, if that's your name, then unless you have some other view of the court rule and you cite a court rule, the court is going to feel the jurisdiction has been established.
I understand, Your Honor, but respectfully, the name in all caps represents a corporate legal fiction. I am here as a living woman, not as a surety or a fictional entity. I respectfully require the court to establish, for the record, how to obtain lawful personal jurisdiction over me, the living woman, separate from that entity.
Well, I'm going to enter a not guilty plea on your behalf. I'm going to give you a $0 bond. I can either give you into the breakout room with the city with an attorney, and he can help you proceed, or you can proceed and speak to the city attorney yourself to see if you can work this matter out, or I can set a jury trial date and the matter will be resolved on the jury trial date. Which one would you like to do, ma'am?
Are you asking me if I would like to proceed for trial?
Yes.
I would respectfully, Your Honor, I would like to reserve all my rights under the UCC 1-308, and I object to these proceedings under protest and duress. My appearance is special and not general. I do not consent to the court assuming jurisdiction through presumption. If this court insists on moving forward without proving lawful authority over the living woman, I must note a violation of due process for the record.
Okay. So, I mean, if you can't give me an answer to my question, then I'm going to put you back in the waiting room until you can figure it out, and we'll move on to the next person.
What is your question, Your Honor?
I asked you, do you want to see if the attorney can get you an offer and speak with the attorney, or would you like to work out an offer with the city yourself to resolve the matter, or would you like me to set a jury trial date? Those are your three options.
You
keep on saying that same stuff is not going to change what your three options are, okay? So that's that. I don't need to hear that same recitation of what you just mentioned a minute ago. Now, what do you want to do?
So I'm sorry, respectfully, Your Honor, I do want to know, is this denying the abatement plea?
Say that again.
Is this denying my abatement plea?
I'm not getting into this, ma'am. I'm going to pass the matter. All right, let's go to what is that? Guerrant Mendez.
Well, guys, we've come to the end of this proceeding, and Miss Destiny, you know, she was pretty young. It looks like she was even live streaming from a church, but same sovereign citizen script jurisdiction. Obviously, we could see that she was reading off a script. And normally with Judge Perkins, not always, but a lot of times he'll give a little energy to the whole sovereign citizen argument, say a few words. But today, it seems like he didn't have any patience for it. You know, he pretty much didn't entertain it. And after she kept repeating herself, he just was playing with her and said, listen, you know, that repeating yourself, saying the same thing over and over is not going to help you. And as we see, he moved on from her. And unfortunately for Miss Destiny, she did not return. And the reason why I say unfortunately is because, you know, who knows if they're going to mess around and give her, you know, a failure to appear or some type of bench warrant. I mean, who knows? Normally I would go and check it out before I do the video, but I didn't get a chance to. But I'll go and check it out and make sure I update you guys on that, or at least we'll find out when the next time she's doing court, and hopefully she shows up without the nonsense. But with that being said, guys, as always, thank you for joining me. Don't forget to like, subscribe, share, all of those great things. This is Sovereign Citizens Hall of Fame, guys. And for now, Sovereign Citizens Court is adjourned. I appreciate you guys. See you guys soon, and God bless.
I'm not threatening you. Say one more word, and that's 30 days. 30 days.